Hi, everybody. My name is Ann Jans, and I'm the new gift planning officer here at KML. So, welcome to the April edition of the KML Legacy Foundation vlog. Today we're going to talk a little bit about something that I think we all know we need, but maybe have been putting off. And that is to set up a will or an estate plan. But if you've been putting off this process, believe me, you're not alone. Even a simple plan can make a lasting impact for you and your family. So today, we're going to talk all about wills and trusts and estate plans, and we are welcoming attorney Robert Mielek to the vlog. So Rob is a trusted local attorney and a friend and partner of KML. So he's going to answer all of our questions today about wills and trusts and estate plans. So Rob, welcome. Thanks for being here.
Thank you for having me. I'm looking forward to this opportunity.
Oh, good. We're so glad you're here. So first of all, Rob, I think that I've heard that many adults in the United States probably don't have a will or estate plan. Is that true? And do you have some statistics that maybe prove that?
I do. So basically, again, statistics will vary, of course, but depending on whom you poll and how you poll people, things like that, how you frame the question. So there's a lot of noise when it comes to statistics. But what I can tell you, in my experience, is it tends to be typically between 70 and 90% of American adults do not have an estate plan. Now, when you hear the number 90, that might sound a little alarming, but keep in mind, adults means everyone over the age of 18, right? I mean, if you pair it out by age, if you take, let's say, the demographic between 18 and 40, that number's going to be probably over 90%. But if you look at, let's say, people over the age of 60, it's going to be a lot lower than 90%. So we aggregate them all together. But again, as we'll talk about as this vlog goes on here, is the idea that everyone over the age of 18 should have some form of estate plan. It may not necessarily take the form of a will or a trust, but there's varying levels of estate plans, various things that an estate plan can do. And again, everyone over the age of 18 needs to have something in place.
Okay, that completely makes sense. So why is it so important though? What happens if somebody dies without a will or estate plan?
Sure. So the simple answer is, and again, everything I'm going to say here today in this presentation is based upon Wisconsin law. 50 different states have 50 different laws. So I can't comment on laws in different states, but I can tell you in Wisconsin, simply put, if somebody passes away without an estate plan, the state of Wisconsin creates one for them. And again, that doesn't mean that the state of Wisconsin gets all of your money. That's one of the misconceptions out there. It's not as though the state gets everything, but what does happen is the state has a series of laws that determine where assets go if people pass away without an estate plan. Maybe it matches what you want, but oftentimes it doesn't. So by creating an estate plan, we empower ourselves to take the money that we've worked hard for during our lives and to make sure that it goes to the people and the causes that we want it to go to with minimal cost, time, aggravation, and governmental interference. That's what a well-drafted estate plan can do for you.
Right. And I think that's what everybody wants. So let's talk a little bit about powers of attorney. It sounds kind of complicated, but I don't think it needs to be. So what are those and why are they so important?
Sure. So that kind of ties into what I was saying before about how every person over the age of 18 needs to have an estate plan in place. And for most 18-year-olds, that takes the form of a set of both healthcare and financial powers of attorney. Again, your average 18-year-old does not need a will. Your average 18-year-old certainly doesn't need a trust, but they do need to have those powers of attorney. So starting at a basic level, there are two types of powers of attorney. There's a financial power of attorney and a healthcare power of attorney. I typically start with the healthcare power of attorney because I find it to be a little more intuitive and arguably more important. Healthcare power of attorney allows you to nominate people who can make medical decisions if you're alive but incapacitated. Tying that back to the average 18-year-old, I'm going to state three facts about the average 18-year-old in the state of Wisconsin. It doesn't apply to all, but it applies to the overall majority. Fact number one, the average 18-year-old turns 18 while he or she is still in high school. Okay. Some of us have summer birthdays. I have a July birthday. I was 17 when I graduated high school, but then turned 18 right after I graduated. But the average 18-year-old reaches their 18th birthday while still in high school. Fact number two, the average 18-year-old still resides with their parents on their 18th birthday. Of course, there's exceptions, but the overwhelming majority still live with their parents. Number three, on the day the average 18-year-old in Wisconsin turns 18, they are usually on their parents' health insurance. Okay, to summarize those facts, average 18-year-old is still a senior in high school. Average 18-year-old is still living with their parents. Average 18-year-old is still on their parents' health insurance. None of that matters when it comes to the healthcare power of attorney. I'm going to give a basic example. For those of you who don't know, I have two sons. I have a 16-year-old and a 13-year-old. So to make this easy and illustrative, what I'm going to do is I'm going to fast forward time to a date that really isn't that far off here, February 6th of 2028. Okay, I picked that day very specifically because that is the day my oldest son, Grady, turns 18. Okay, he will be a senior in high school. He will be living with his parents as long as we're still alive, and he will still be on our health insurance. He drives to school that day. He still doesn't have his license at 16. That's a different issue. We'll talk about that. That's beyond the scope of the vlog here, but he drives to school that day. He is in a horrific car accident. He's in a coma. He's taken to the hospital. He's unresponsive. Even though we're his parents, he's living at our home, he's still in high school, he's on our insurance, we as parents cannot receive any information regarding his injuries, his care, his prognosis, unless he has a healthcare power of attorney in place. Why is that? It's because of a series of laws referred to as HIPAA. Most people have heard of HIPAA. It is the Health Insurance Portability and Accountability Act. It's a federal statute that, among other things, determines when and under what circumstances medical providers can share your medical information. And they cannot share it without consent. And if the 18-year-old reaches the hospital and does not have the ability to provide that consent because, like I said, they're in a coma, that information cannot be shared. So as parents, that's the most important thing we can do, because imagine how difficult that would be if our child is in that situation and we are powerless to receive information or even see our child at that point. Every single person over the age of 18 should have powers of attorney. We just talked about the healthcare power of attorney. Another thing I want to emphasize with the healthcare power of attorney is that spouses do not automatically have that right either. That also surprises people. A lot of people assume, well, they use the phrase Wisconsin's a marital property state. Yes, it is a marital property state, but that has no bearing on HIPAA whatsoever. So same thing. I drove here today. I get in a car accident. I'm taken to the hospital. I'm in a coma. If I don't have a healthcare power of attorney, my wife not only can't make medical decisions, cannot receive any information regarding my care, my injuries, my condition, my prognosis, because I can't share that if I'm incapacitated. So that's the importance of the healthcare power of attorney. But the financial power of attorney has importance too, even for that 18-year-old. Now, most 18-year-olds don't have much by way of finances saved for maybe the money they saved at a summer job, things like that. They nevertheless need a financial power of attorney because a financial power of attorney really is the anything but healthcare power of attorney. So for instance, if we need to deal with an insurance claim, if we need to deal with a high school, if we need to deal with a college, technically the moment they turn 18, we as parents lose the ability to make those decisions. Same thing with married couples. Most married couples own most of their assets jointly. Most married couples, if they own a house, it's in both spouses' names, joint checking, joint savings, things like that. But there are 5 very common assets, and I'll walk you through them. Traditional IRAs, Roth IRAs, 401ks, 403bs, and life insurance. Those are 5 pretty common assets. Those assets cannot be owned jointly. It's not possible. Okay, so what ends up happening is those assets are in one spouse's name and they list their other spouse as a beneficiary. So if I have an IRA, I list my wife Erica as the beneficiary. If I die, she gets the money. Pretty straightforward. But if I'm in that same accident I described before, and I'm in a coma for a couple months, and my wife needs that money to pay bills, as a beneficiary, she can't access that money because I'm still alive. We would need a power of attorney to be able to access that money. So again, I take the position in my practice, every single person over the age of 18 should have that basic form of estate plan in the form of powers of attorney.
Oh, that is such good information to know, because people would think my spouse or my child, I should have this ability, but that is not the case. So it's such good information, especially for parents of these young adult children who just turned 18.
You bet.
Right.
And there's so much misinformation or disinformation as it relates to estate planning. So that's why I present the facts here and let people make their own decisions. But again, as consumers, as human beings, we cannot make fully informed decisions until we have full information. And that's what I'm attempting to provide for the audience here today.
Right. And we appreciate that. That's why you're here and you're breaking it all down for us.
You
So
bet.
thank you. So Rob, let's talk a little bit about wills and trusts. What is a will and what is a trust? What are the differences and when is each appropriate?
Sure. Most common question I get asked in my practice by far, because there's so much information out there. Information comes from the internet, comes from friends, family, who 99% of the time have the best of intentions. Most people aren't intentionally trying to sabotage their friends or family members with incorrect legal information. The problem is these folks are not lawyers, let alone estate planning attorneys, so sometimes they get it wrong. They don't understand the nuance, law changes, things like that. So let's break this down very simply. Whenever I get asked this question, I always start with what a will is, what it does, but then maybe more importantly, what a will does not do. Okay. So a well-drafted will is always going to do two things. And when applicable, and when it is applicable, it's the most important thing an estate plan can do, does a third. First thing a well-drafted will does is determine who are your beneficiaries. Who or what, in the case of charities, are going to receive the proceeds of your estate after you pass away. Second thing a well-drafted will does is determine who's in charge. I'm sure you've heard the term executor before. You appoint the person who's responsible for making sure all assets are funneled into the trust, final expenses are paid, proceeds are distributed in accordance with your wishes. Third thing a well-drafted will does when applicable, and again, most important thing we're going to talk about here today, guardianship of minor children. Okay. That is one of the biggest misconceptions I run into in my practice. And I deal with that a lot because I have the two boys who are 16 and 13. I coach football. I coach hockey. I deal with a lot of parents of teenagers at this point in my life, right? The only way to determine guardianship of minor children in Wisconsin is either through a will or a trust. Literally nothing else works. I have had so many people say, well, I have a notarized letter saying my sister gets the kids. Worthless, completely unenforceable. Unless it is in either a will or a trust, a court is going to hold a hearing to determine guardianship of your children. So as the parent of two minor children, there is nothing more important than that here today. Just establishing a document, either a will or a trust, that determines guardianship of those minor children. So to summarize, a well-drafted will: who gets the money, who's in charge of the money, who gets the kids. That's what a will does. Now I'm going to explain what a will does not do, okay, that a trust does. A well-drafted will is not guaranteed to avoid probate. And that surprises some people. People say, well, I thought if I had a will, it's going to avoid probate. To be clear, will-based plans can avoid probate, but they're not guaranteed to avoid probate. So let's briefly define probate. Probate, I'm sure, is a term most people in the viewing audience are familiar with, but I'm going to boil it down to one sentence. Probate is the process where a court oversees the administration of an estate. The estate goes to probate. We have a series of hearings, series of filings, series of deadlines, series of events that occur before assets go from the name of the deceased to the name of the intended beneficiaries. Simply put, as an estate planning attorney, I encourage my clients to create plans that are guaranteed to avoid probate. Why is probate avoidance so important? 3 reasons. First is cost. Average cost of probate in a state right now in the state of Wisconsin is between $8,000 to $12,000. The second is timing. The average length of probate is 12 to 18 months. The third issue is publicity. When somebody passes away and it goes through probate, the will becomes public record. Not only does the will itself become public record, but the amount and the character of the assets also become public record. So to summarize, 3 negatives of probate: cost, $8,000 to $12,000, timing, 12 to 18 months, public record. How do we avoid probate? And this is really where the crux of the decision between will and trust comes into play. Way number 1, if we take a single person or the second of a married couple to pass away, and we fast forward to the day they pass away, if at that moment in time the value of that person's probate assets is less than $50,000, that is considered a small estate, and a will-based plan avoids probate. Now, of course, the opposite of that statement is also true. If we fast forward to that moment, the probate assets exceed $50,000, and we only have a will, the estate goes to probate. Now, for most people in the listening audience or viewing audience, they're going to be over that threshold. The only way to guarantee we avoid probate is to create a trust. So that's the difference. The trust creates the guarantee. Again, can we avoid probate through having less than $50,000 or having named beneficiaries? Sure, we could. But it's not a guarantee. The trust creates the guarantee, and it does so for a very simple reason. If we have human beneficiaries, okay, even if these human beneficiaries are 1, maybe even 2 generations younger than us, we don't know whether they're going to survive us. We hope they do. I mean, everybody hopes their children and grandchildren survive them, but unfortunately, we don't know that. And we won't know that until the day we pass away. The trust, on the other hand, unlike any human being on this planet, has a 100% chance of surviving us because the trust can't die. So that's kind of the overarching logic of trust-based estate planning. We are creating an entity, the trust, that is guaranteed to survive us, and that's how we know the estate will avoid probate.
Okay, so trusts are generally a little more expensive than
Yes.
setting up a will, but even though they might be a little bit more, have more upfront costs,
Yes.
in the long run, they could be, help with the cost of that and the time savings just because of what they avoid.
Absolutely. I mean, if the average cost of probate in a state is $8,000 to $12,000, the cost of a trust, at least at my firm, is nowhere near $8,000 to $12,000, right? So
Right.
that alone is an issue. The analogy I draw is this, because I do have some clients who will quarrel about the pricing, and I'll give them an analogy. If they're meeting at one of my offices, okay, and I do have 4 office locations, but they go to my office and they ask about the differences. They'll say, well, the will-based planning is more cost effective. Why don't I do that? I said, let me ask you a question. You purchased a vehicle, right? Bought a car. Why didn't you buy a bike? You could have biked here today. Get more exercise, get to be out in the environment, but you bought a car. Why'd you buy the car? The car was a lot more expensive than the bike. Well, the car does more for you. It gives you the comfort. It allows you to travel in anything. So it's not necessarily looking at the cost, it's the value for the cost. And usually when I draw that analogy for people, they kind of understand that. As a courtesy and as a gift, frankly, to the people who are going to be in your place after you pass away, it's important to make sure that we have a plan that avoids that probate process and that makes it as easy as possible for the people to focus on grieving and going on with their lives, as opposed to having to deal with lawyers and financial people after someone passed away. That's the benefit of the peace of mind that comes with having a well-drafted estate plan.
Okay, no, that makes sense. And you talk about trusts. I think there might be a misconception out there that trusts are only for people who are very wealthy. But from what you said, that really is not true, is
Right.
it?
Here's what I would say. I would say most people who are viewing this vlog own real estate. I'd say most people who own real estate have equity in the real estate that exceeds $50,000. These people are candidates for trust-based planning because if they don't have it, the estate goes to probate. So again, I don't think most people, I mean, wealth is relative, right? I mean, for someone, $10 million is a pittance. For other people, it's a life's fortune, right? We just don't know. It's all relative. But having that more than $50,000 amount of assets indicates that you probably should consider a trust if you want to guarantee we avoid that probate process. And like I said, equity in a home is usually the biggest culprit there.
Mhm.
That usually pushes us over the threshold, particularly with how real estate markets have gone lately. I mean, usually when you buy a house, you buy a $300,000 house, you put 20% down. I mean, that's your $50,000 right there. So again, that's where I typically look, and that has nothing to do with natural appreciation of real estate, which almost always happens anyway. So again, I do always try to dispel that myth that trusts are only for the wealthy. It's really for anybody who has more than $50,000 worth of probate assets.
Okay, well, thanks for helping us
Oh, it's
understand
my
that.
pleasure.
Another thing too, can you talk a little bit about privacy when it comes to wills versus trusts? Because
Sure.
some people don't want their information to become public record. So can you talk a little bit about that?
Absolutely. So what I'll do in order to explain that is I'll explain a hypothetical, okay? Let's assume that as a 44-year-old myself, I did anything other than what I did for a living. Because I do what I do for a living, so I'm a little biased, okay? I have any other job imaginable. And I learn about this guardianship issue with the children. And I say to myself, I say to my wife, gee, this is really important. We need to have that in place. But let's just say the attorney I worked with wasn't perhaps as up to speed on trust or the benefits of trust, and they just had me create a will, okay? So I create a will. My wife and I both suddenly pass away in a car accident. What happens? Well, again, if the probate assets exceed $50,000, it goes to probate. Somebody, whether typically appointed by the will, but not necessarily, would serve as what's called the executor. That person would have to open up a probate matter. Among other things, they have to disclose what assets went into the estate and what assets came out. So that information, my house is worth this, my accounts that didn't have beneficiaries are worth this, all of those things become public record. And anybody could access it. I'm sure most people in the viewing audience are familiar with CCAP, okay, Circuit Court Access Portal, right? Usually people do that for criminal type things. You hire a babysitter, you want to make sure the babysitter doesn't have any previous convictions. So you look him or her up on CCAP, right? That's what 98% of people use it for. But CCAP also has estate planning information on there too, because they're all public record, no different than criminal charges are. So again, that information could become public, and there are people out there who may use that information with bad intentions. They may say, okay, well, now you have a 16 and a 13-year-old who just received all this money. Their parents passed away. Maybe they're targets for predators. Maybe there's people who want to take advantage of that. And again, we avoid all of that by creating a trust. Essentially, what I always tell my clients is a trust privatizes the estate administration process. That's pretty much what it is. It does not get involved in courts. You've set up a mechanism to have it bypass the courts, and it's administered without the benefit or the assistance of the courts.
Okay, that makes sense. And I'm sure that's what people want,
You
right?
bet. You bet.
Okay.
Privacy is a big thing. I mean, it's
Yeah.
important, especially when you're talking about having minor children. It's very important. And, the example I give is forget just having that be public. As human beings, we don't want that information shared. I always tell my clients when it comes to the will itself, I have no problem sharing what my distribution pattern would be, right? Everything to my spouse first, divided evenly between my two sons after that. That's fine. That can be public record. But the amount and the character of the assets I have, I don't share that with many people, right? My accountant knows that. My financial advisor knows that. My wife and I know that, but that's about it.
Well, that completely makes sense. So thanks for explaining that to us.
You bet.
So here at the KML Legacy Foundation, we are big proponents of setting up a will or estate plan, just like you are, right? Because we know it benefits our loved ones, and also it can benefit the ministries or the charities that we love, like our congregation or KML. So because you are such also a big proponent of setting up a will or estate plan, you've made a very special will or estate plan offer to our KML families. Can you just explain that to us a little bit?
Sure, I'd be happy to. So again, it's kind of a little confusing, so let's clarify this here. Okay, so if somebody comes into my office, they were referred by KML Foundation or affiliated with KML in any way, we're going to be in one of two groups. Okay, people who want to have a will-based plan set up. I will do a will-based plan for an individual or for a married couple for a flat fee of $250. Okay, they pay that money to me. I then donate that $250 back to KML. That offer is limited, however, to people where at least one spouse is under the age of 30 or my clients who do not own real estate. Because candidly, most people should have trust-based plans, in my opinion. It's that kind of distinct group of individuals who don't own real estate or under 30. A will-based plan is what I would recommend in that case. So the majority of people are not going to be in that situation. But for the people who are, they pay $250, they get their wills, they get their powers of attorney. That all goes back to KML. On the other hand, my clients who want to have trust-based planning, what I do is I quote them my normal price to do the trust and the powers of attorney and everything else. I reduce that fee by 25% because of the affiliation with KML. Whatever that new dollar figure is, I take $250 of that fee once they pay it to me, and I donate that back to KML. So either way, KML is getting a $250 donation. It's just in one situation, it's part of the entire will, or in another situation, it's part of the fee from the trust.
Thank you, Rob. It's a wonderful offer, and thanks for explaining it so simply to us.
You bet.
We really appreciate that. So thank you so much for being with us today. Thank you for answering all of our questions about wills and trusts and estate plans and probate and powers of attorney and things like that. You are such a valued partner to us at KML, and we are so thankful to you for everything. So thank you again for being here today.
My pleasure. Thankful to you guys as well. Have a great day.
Thank you. Well, thanks everyone for joining us today and learning more about wills and estate plans and how they can be a blessing not only to you and your family, but also to the charities or the ministries you love, like your local congregation or KML. So if you're interested in working with Attorney Mielek, or if you would like a free packet of resources that I can provide to you to help you get ready to meet with Attorney Mielek, just reach out to me here at KML. We'll put his contact information and mine in the description below. And if you're a member of our Heritage Society and have remembered KML in your will or estate plan, or if you're interested in doing so, reach out to me as well. I can walk you right through that process. Remember, it's your life, it's your plan, and your legacy, and I'm here to help you every step of the way. So join us again next month, where we'll talk to KML Legacy Foundation Board Chair, Mr. David Zarling, about the power of endowments, how they support tuition assistance here at KML, and how you can be part of the process. So thanks again, everybody. Take care, and God bless.